Um, this is a recap of two issues in removal that I think are often a little bit tricky dealing with situations involving 1332 SMJ. In particular, the so-called in-state defendant bar under 1441B, and then the separate bar under 1446 when removal is attempted based on an amended claim, or rather amended complaint, sorry. So before we jump into these, let's first start with the basics of removal. So here is the basic statutory provision for removal, except when there is a more specific statute. That's the gray part in the text. So if there is a particular situation where Congress has provided special rules, you would follow those. Otherwise, this is the default for all cases initially filed in the state court that are removed to federal court. So, what can you remove? Basically, the blue part is talking about what you can remove. Any civil action of which district courts in the United States have original jurisdiction. And that language should sound familiar because it's very similar to 1331 and 1332, basically saying that where the district courts have subject matter jurisdiction, then the case can be removed by the defendant from state to federal court, even though the plaintiff didn't elect to sue there originally. Now, it may be removed, but it need not be removed by the defendants. It's up to the defendants to decide that. But if the defendant does remove, they don't have free rein to decide where, unlike the plaintiff, who may file in any federal court which satisfies the other jurisdictional requirements, PJ, etc. And although this provision says it may be removed by defendant or defendants, as you should know from 1446, if there is more than one defendant, generally they all have to agree to removal. So where it talks about defendant or defendants here, they're just talking about whether there is one or more than one defendants, it may be removed. So that's the basic provision. Now, let's get a little more complicated in 1441B. So looking at 1441B on the left, says a civil action otherwise removable, i.e. removable under 1441A, if it's solely removable on the basis of 1332, then you have a problem. In particular, it says it may not be removed if, and this is the important thing because it's not a bar to all 1332 SMJ cases, it's only if it's removal of a case with federal SMJ only based on 1331, or rather, 1332. So if it has 1332 and 1331, this doesn't apply. It's only if federal SMJ is 1332 only. You can't remove if any of the defendants is a citizen of the forum state. So if the initial state court action was filed in Illinois, and there were 5 defendants, only one of whom was from Illinois, that would be barred. Even though the other ones aren't from Illinois, this says any of the parties is a defendant. Now, what seems to be causing some people trouble is whether this rule, this in-state bar, changes the complete diversity rule. The short answer is no, but it's important for you to understand why. Now, the complete diversity rule, as you know, says that all the plaintiffs have to be of a different state citizenship from all of the defendants in a cause of action based on 1332 SMJ. So that is absolutely always required. This doesn't change that. It just says even if you satisfy all the rules for 1332, including complete diversity, you still cannot remove if you are the defendant. So, whereas a plaintiff who is filing a lawsuit can file wherever they want in a federal court with SMJ and PJ with a 1332 case, a defendant trying to remove that same case is limited if one of the defendants is a citizen of the state where the action is brought. So this makes it narrower the situations where the defendant can remove, which is constitutionally permissible because there's no reason that Congress has to give the same rights to the defendant as a plaintiff, because usually the defendant has no rights at all in deciding anything about where the lawsuit is filed. That's the plaintiff's prerogative. So this is really, you can think of a removal as an exception to the usual rule where the plaintiff is the master of the complaint. So now that you understand the basics of how the 1441B bar works, let's look at some examples. Okay, so on the right is, or rather, sorry, left is still the statute, and there's 4 situations on the right that we should work through. First situation, plaintiff from Massachusetts, defendant from Illinois, over $100,000. So this should obviously satisfy 1332. There's amount in controversy and there is complete diversity. But the defendant here from Illinois cannot remove, because this is a case with solely 1332 SMJ, and the defendant is from the same state where the cause of action was filed, Illinois. So that is barred from removal. Now let's look at the second scenario. It's a variation on the first, still filed in Illinois, but now there's an additional defendant. So now there is a defendant who's not from the form state. Does that change it? The answer is no, because the statute says if any of the parties is a defendant from the form state, no removal, and B is still from the form state. So situations 1 and 2 cannot be removed. Now let's look at situation 3, where we still have complete diversity, Massachusetts versus Illinois, and amount in controversy, but now, because the plaintiff sued in California, that is a different state than the defendant. So because the defendant is from a different state than the forum where it was filed, removal is totally fine. So even though the parties are from the same places as the first situation, this is fine, just because the plaintiff happened to have filed in a location different than where the defendant is a citizen of. Now, one last scenario, the last one, it's similar to what we've talked about before. There's complete diversity, but now we're adding one more claim. And importantly, this claim for a federal labor cause of action would arise under 1331 SMJ, because as you know, if there's a federal cause of action, there is 1331 SMJ. So B is still a citizen of Illinois, where the cause of action was filed. Is this barred from removal? The answer is no, because in this case, federal SMJ is not solely because of 1332. There is an additional 1331 claim, so that is also removable. So the last 2 situations are removable. So let's move on to the final issue that is, I think, a little bit tricky about 1332, and that is the so-called 1-year bar. So this, again, only applies to 1332, and what it's saying is that if the initial case was not removable, as in our first example, where there is no amount in controversy, because 1,000 is not exceeding 75,000, but after 2 years, if the plaintiff files an amended complaint that states something, can it be removed? Now, there's 2 different situations. In one, the plaintiff adds an additional tort claim that has federal SMJ under 1332. But in the blue scenario, the new claim is a federal civil rights claim. So you should know that generally the defendant has 30 days to file a notice of removal, but under C1, even if you're within the 30 days, you really can't properly remove if your basis of removal under federal SMJ is 1332. So because it's 2 years, the second scenario, the intentional tort, it would be precluded. Whereas the civil rights amended complaint, that could be removed. And as you should remember, the whole case, the battery and the civil rights claim, would be removed, and then the federal court could remand back the battery claim if that doesn't meet the amount in controversy. Now, this additional restriction on 1332 cases is only if it's more than 1 year from the original complaint starting. So if the amendment is 6 months from the commencement, there wouldn't be a problem even if it was under 1332. So you just have to be very careful with these additional restrictions on 1332 about all the nuances. But hopefully this helps a little bit to cement your understanding. That's it.